GCSB or the Inspector General.
Call Dr Russell Norman.
Mr Chair, I rise on behalf of the Green Party to speak about Part 2 of the GCSB bill. This part is particularly related to the role of the Inspector General of Intelligence and Security. And I agree with Mr Robertson that there are some improvements in terms of the role of the Inspector General of Intelligence and Security in this part, but nonetheless it remains fundamentally flawed. The improvements are around essentially resourcing, which is the deputy role that's been introduced, and increasing the pool of candidates who can be appointed to this position, and there's some good changes. However, I think there is a fundamental structural problem that we're dealing with here, and it relates to Part 1. In Part 1 of this bill, we effectively gave dramatically increased powers to the GCSB and the SIS. And then in Part 2, we're saying the Inspector General of Intelligence and Security will be the watchdog as to whether those powers are exercised properly. The problem is that the IGIS, the Inspector General of Intelligence and Security, even with the best intention of the world, may have to sign off things as lawful and acceptable that they consider to be gross breaches of human rights, gross breaches of privacy, because they have been made lawful by the changes made to Part 1 of the bill. And that, I think, is the fundamental conceit in the changes made around the oversight provided by the Inspector General of Intelligence and Security. Because if, on the one hand, you allow the SIS, and particularly the GCSB rather, to have significantly increased powers, and as we saw, they're very focused on New Zealanders, the increased powers under Part 1 that this bill provides, then when the Inspector General is facing applications by the GCSB to do certain things and is trying to provide oversight to make sure that the GCSB is acting lawfully, of course the GCSB has acted unlawfully over 80 times previously, when the GCSB makes those applications or does those actions and the Inspector General is meant to provide oversight, they'll have little choice but to say, actually, it's lawful. It's lawful to engage in mass surveillance of New Zealanders because the law says they can do it. And I think that is the fundamental problem and the way that this is actually so flawed. The Inspector General will be forced to agree, forced to sign off, to give some kind of stamp of approval to actions that they may otherwise consider to be ethically wrong. The other part of this that I want to talk about is the much better framework that we could have had introduced at this point, which was essentially to make the Inspector General of Intelligence and Security an officer of Parliament rather than a creature of the executive, appointed by the executive, if you like. And I was very pleased to hear Mr Robertson's contribution on that point, because the Greens have argued for many years that the Inspector General of Intelligence and Security should be an officer of Parliament, and we've had disagreements with Labor about that in the past. And I'm very pleased to hear Mr Robertson now say that he personally, at least, agrees with that position, and I think that offers hope that in the future we can actually make the Inspector General position an officer of Parliament. Running alongside that, of course, it would need to report to a select committee of Parliament, and that refers to Part 3, which is to make the Intelligence and Security Committee, rather than a statutory committee, make it a regular select committee of Parliament. So the much more, I think, proper way to provide oversight of these kind of agencies is to have an Inspector General who is an officer of Parliament, independent of the executive, and so able to provide that kind of independent oversight of what the executive is doing, because they report to this House, to Parliament, to this branch of government, rather than having the very close relationship with the executive that the Inspector General has. And then running alongside that, I think it's also, you would have to have the Intelligence and Security Committee established as a committee of Parliament and operating under regular standing orders rather than the statutory committee with no powers. The other part I'd just like to mention here that I think is important and I think is probably not really understood about the constraints that will be on what the Inspector General of Intelligence and Security can say, and that relates to the amendments to Section 25, which is about reports. What this means, the changes here, is that if the Inspector General of Intelligence and Security finds something in that they want to tell the public about, they will have significant constraints on their ability to tell the public about what they found. Because as it says here that in these kinds of reports, any matter quoted or summarised in the report by the Inspector-General must be given a security classification not less than the security classification of the matter quoted or summarised. What this means is that the GCSB, Mr Chair...
Dr Russell Norman.
Thank you, Mr Chair. That the GCSB can, for example, categorise a piece of information as at a very high level of security, which means that very few people are allowed to see it. They might call it top secret, for example. Then if the Inspector-General finds something remiss around this and tries to introduce it into one of their reports, that report won't be able to be published to the general public, because the same security classification that the GCSB applies will have to be carried over to the Inspector-General's report. This seems like a minor technical issue, but is a very significant constraint on the ability of the Inspector-General to talk to the public of New Zealand. Because if the Inspector-General's role is to provide a check on what the GCSB is doing, to provide a watchdog function, a key part of that watchdog is that they should be able to communicate to the people of New Zealand. That will be one of their key powers, is the ability to write this report, or these reports. They won't be able to make these points because if the material that they're quoting from, or even summarising, is classified as top secret, it cannot go in the public version of the Inspector-General's report. So the Inspector-General will be constrained by the very agency that they're meant to be the watchdog over in their ability to report what that agency is doing by these sections. And I think that is one of the basic problems in this. I just want to also touch briefly on a couple of amendments, or supplementary order papers as they're called in the technical language of Parliament, to this part that I've moved. One is, firstly, is just set out in supplementary order paper 311, and that's simply to add privacy as one of the policies that the Inspector-General can order. We think that privacy has been a critical issue in a lot of these debates around the GCSB and other issues related to it, and so we think that it's important that privacy should be added to the list of the policies that the Inspector-General can audit as a key part of the legislation. And the other part of it is around, this is Supplementary Order Paper 3112, which is an amendment to Clause 34. And what we're trying to do is make sure that when the Inspector-General reports to the Minister about an issue, as currently happens, the Minister then responds to that. But the Minister doesn't have to provide that response to the Intelligence and Security Committee. So the Intelligence and Security Committee will never see what the Minister's response is to the Inspector-General's report. They may, but it's not a requirement that they do. So essentially we replace may with must. So the Minister must provide their response to an Inspector-General report to the Intelligence and Security Committee. I think this logically follows. If we want the Intelligence and Security Committee to provide the kind of oversight over these agencies, then it needs to see what reports the Inspector-General is writing about the GCSB and other agencies, the SAS in particular. So the Intelligence and Security Committee needs to be able to see those reports, but they also need to be able to see the Minister's response to those reports. Because how can the Intelligence and Security Committee provide the oversight that we're asking of it to provide if it doesn't know necessarily what the Inspector-General is saying, but particularly if it does not know how the Minister is responding to any concerns that the Inspector-General is raising? The Intelligence and Security Committee is very constrained in its ability to inquire into, for example, the operational matters of the GCSB and the SAS, which means that the ISC is very limited and quite reliant on the Inspector-General of Intelligence and Security to provide a watchdog function over the operational matters of the GCSB and also the SAS. And so if the Inspector-General's reports on those operational matters are not going to the Intelligence and Security Committee, and if the Minister's response to the concerns being raised by the Inspector-General are not going to the Intelligence and Security Committee, how on earth can that committee be confident that it is providing sufficient oversight of the operations of the GCSB when it doesn't even know necessarily what's going on in the communication between the Inspector-General and the Minister, or in this case the Prime Minister, and the Prime Minister's responses to the concerns that the Inspector-General is raising? And that's why I've moved the amendment set out in Supplementary Order Paper 312 to make sure that the Intelligence and Security Committee gets access to those particular reports. In general, I think it is important to make the point on the oversight issue that so many of the positions, in fact all of the positions that provide the oversight, are appointed essentially by the Prime Minister. So there is a fundamental problem of oversight. Even the Intelligence and Security Committee has a majority by the Prime Minister and their allies. So there is a fundamental, I think, lack of oversight here.
The Honourable Phil Goff.
Mr. Chairman, Part 2 of this bill deals with the role